Start. Para. The petitioner institution is aggrieved by two interim orders, both dated 6/5/2023, passed by the Grievance Committee, Rashtrasant Tukadoji Maharaj, Nagpur University, Nagpur, in favor of respondent number 3 in the both petitions in grievance petition numbers 10/2022 and 11/2022 in favor of respondent number 3 in the both petitions. The grievance committee has directed the petitioner institution to release full salary of respondents number 3 from the date on which the period of 6 months is completed from the date of the suspension of the respondents number 3. Para. As stated earlier, these orders have been passed on 6/5/2023. The respondent number 3 in respective petitions lodged complaint on 16/3/2022 before the grievance committee challenging the orders of suspension passed by the society which runs the petition institution. The suspension orders were passed on 11/3/2022 and 10/3/2022. The counsel for petitioner contends that on the date when the grievance committee has passed impugn orders, it had already lost jurisdiction. On this point, I have heard both sides at length. Section 79 of the Maharashtra Public Universities Act 2016 provides for constitution of grievance committee to deal with all types of grievances except the grievances against the state government, including its officials, teachers and other employees of the university, affiliated and autonomous colleges and recognized institutions other than those managed and maintained by the state government, central government or a local authority which are not within the jurisdiction of the university and college tribunal. Para. Since Section 79 of the Act of 2016 did not provide for procedure to be adopted by the grievance committee to deal with the grievances which are within its jurisdiction and which are brought before it by affected persons, the Vice Chancellor on 25/2/2022 issued directions to that effect under direction number 12/2022. These directions have been issued under subsection 8 of section 12 of the Act of 2016. One can understand the importance of issuance of directions from the wordings of subsection (8) of section 12 of the Act of 2016. As is evident, the directions will be required in an extraordinary situation where the Vice Chancellor finds that the matter is required to be regulated by the statute, ordinances or regulations, but no statutes, ordinances or regulations are made in that behalf. In such an eventuality, while the Vice Chancellor is empowered to issue directions, he is duty bound to place such directions before the Management Council or concerned body at the earlier for approval and to also place draft of the statute, ordinances or regulations as the case may be. Considering the importance of issuance of directions, the proviso to subsection (8) further clarifies that such direction, if not converted into statute, ordinances or regulations as the case may be, within 6 months, the direction shall automatically lapse. This implies that the business required to be regulated by the statute cannot be regulated by directions which exist as a stop-gap arrangement. The Vice Chancellor should therefore expeditiously place before the Management Council or concerned body the said direction for approval as also the draft of statute. Para. When inquired as to when did Vice Chancellor placed the aforesaid direction before the Management Council for approval, the Council for Grievance Committee upon instructions submits that it was never placed before the Management Council nor was the draft of statute so placed. Stop.